Cancellation. Merely on his bold allegation that police took me out of Gujarat and then got me. I would request this honorable court that this fact has to be put on affidavit by the accused. The only reason is I have all the materials to show, but merely on his bold assertion, this fact may be put on affidavit. They have filed it. They have filed it in written objections in writing. Nothing, sir. Advocate filed it by the signature. Therefore, if he is making, see the allegation he is making against the entire system. Said allegations had manifested how and when in what these circumstances present respondent was taken out of Gujarat and then shown to have been arrested out of state of Gujarat. This is his allegation. No, but sir, then I am supposed to file a fresh affidavit with regard to that content which he has made. Because if he is not filing it on affidavit, we will not be able to take action against him for this false allegation.
We will not be considering it as an allegation, but we will only consider it as an argument. Not more than that. If it doesn't file it,
he was supposed to come in the second sitting tomorrow, today, Mr. Mangu. I told him that let him file this affidavit. In any case, he may be having my evidence.
If in wrong affidavit, is a crime.
Because that is why I am insisting, because they are insisting our additional affidavit or a report from the IM. Because of that allegation. Because of this allegation. Because of this allegation, which they reiterated in the oral submission also. I am ready with everything. But let
I just wanted one thing. Your order has to go into. That's what I wanted.
It is there. Entries are also there made in the local police station. Stationary entries were leaving. They went in the government vehicle. CCTV footages of the toll plazas are also.
It will put us in the
because the main matter is not fixed today. It is a cancellation. He is coming for argument of discharge in second sitting. That is what I. It is not there.
I had suggested discharge only for whether you want to withdraw or you want to go only for that.
He is saying that he is coming in second sitting to argue discharge, which is not listed.
I told them withdraw for what?
Take the high. He is arguing.
I told them that I will going to withdraw or I will.
He can say to his counterpart also. Argue, but I would request his honorable court.
Please, that if you are really making that has value.
Thereafter, I will file my appeal. Because in that case,
I want only that part. Not even affidavit.
A report.
Report.
Sir, 41(1)(I) says that on requisition written in or orally. What is it? It is there.
That's what I mean. I'm not concerned about how it is. What it is. I've got one link to there, right? One link is there. Other link from here.
We have mobile phone details from WhatsApp from
that. I'm not talking about that. I'm talking about one thing is there on the the total. Now one thing has to be from here. So no both. That's what.
Yes. Okay, Parmal. विजय सोलंकी भाई Mr. Dodia is filing appearance on behalf of victims. and he's taking time to file objections. He called me today morning, but his junior does not have instructions. They started it.
That time.
From the chart, from the chart. There are many of it.
That has not been reflected.
No, but this is a standalone offense. Standalone offense. Main offense is the
Section at the.
nothing. It has been standalone offense. Standalone offense. Mr. Georgia wants to file objections for victim.
You were already arguing.
No, sir, by arguing saying continuation, we have sought for that sanction. Sanction is the solution. No, sir. My argument करवानी है, conclude. Remaining.
You had argued.
No, no.
No, we start off with the argument.
मुझे मांगे. For victims. There are several victims in the predicated.
If it's gone, no, but we need to go.
They want to file it.
What?
Objection.
Ultimately,
That the ultimate aim of filing objections is not merely filing objections here. They want their locus standi before a higher forum. Those, therefore, they have to file it here.
logo to see what we are giving in this, we allow you that. As it is your name, I don't think. Appear. Now, how you say this? You want to, why keep it pending? They never knew last time. We be together, but one of them, like, there is not like. I will hear them and then જ્યારે મૂકવું હોય મૂકી દેવું ના મૂકી શકે and everything will be 350 on you now.
And it,
It will be beyond a policy and then
no, prove me. Prove me. It will be on their name.
Kalanama will be your only.
Their local. Prove me. It will be filed through me. They might not argue orally. They will only put in this writing.
To put it, the applicant, no, not the advocate. Who is by
The victim.
the advocate?
The victims.
तैयार बने एडवोकेट करना that is a difference. तैयार करना तैयार करने की देगी. You don't need to file a Pakalatnama. Pakalatnama is already there. Appearance and appearance. And then it's like a statement. You contribute a statement to like તમે બી કહેવાના ને કે ભાઈ આ આવું છે ખાલી પેલું સ્ટેટમેન્ટ વધારાનું કરવાનું છે કે થોડી હજાર કોણ કરે તમે કરવાનું સ્ટેટમેન્ટ બી વધારી દેશો ના વધારે
Nothing. Whether any but why bail should not be granted, they will file their objection. This is the general trend. The victim will come and file objection. Why bail should not be granted.
It's like the
They will give their own version why bail should not be granted. I will give my version. My learned friend will give his version that why it should be granted.
IO doesn't know,
They will give their own version.
or they have not disclosed that to the IO.
Everything has been disclosed. Whatsoever is there.
When will you argue?
Tomorrow we have that Bhavnagar matter scheduled. It will take some time. આખો દી ચેતનભાઈ ની લાસ્ટ ટાઈમ આખો દી ચાલી. it will take some time. It is
It's
tomorrow.
double work.
I have to do some material, but I have to take it for this one.
But you have already argued.
No, no, sir. Then I have then this the sanction point came. બરાબર name સાથે
બીજે સોલંકી
make it from fifth. Right? Go long, for six. No, no, sir. I am not here. You may argue in my absence, I will argue. I am not here. No, no. You may argue today after tomorrow in my absence, I will argue. So, for this is a new touch. તમે ભાઈ વાંધા હું મને આપો તો હા મેં તમે એ આ એ પરમ દિવસ એ નહીં મિત્ર હા remember it was kept on first August, but inadvertently it is kept today. Bhavnagar Wadi, Mr. Pandya. I have given a overview of first August. Right. Paper will be here by 5:30 for preparation. Inadvertently it is listed today. It was to be listed on first August, on 20th on last day. But it is listed today. It may be kept tomorrow. आप पेली भावनगर वाली जो मिस्टर पंड्या जी है ना काले चार नंबर ये नंबर 2
ठीक है पंड्या
हाँ we requested 20 for first August, but inadvertently it is listed.
Sir, the request is kept on 7.
Even
Regular bill. Yes, sir. They have argued, doesn't matter. I don't.
this matter as per my instructions yesterday, this is before charge sheet. Yesterday or day before yesterday, co-accused application has been dismissed on the High Court by detailed level.
That's on the 167.
No, it was on regular, no,
Not regular.
regular.
Doesn't matter.
You have my order, I see the regular with the court.
Take it on because the once on the 167. Doesn't matter when do you want to pick it. On 7. Case transfer to the IVA process.
Poteci evi pokya bhai. Poteci evi pokya bhai.
Range from
Evi pokya bhai.
Okay, yeah. Sorry, order the bill. Hello.
હુસેનભાઈ સિપાઈ વિકેરે 3 જણા હુસેનભાઈ સિપાઈ વિકેરે 3 જણા ધોતેસી પીએમ સાહભાઈ સિપાઈ 3 જણા પછી પીએમ સાહેબ પીએમ સાહેબ મનીષાબેન દિવ્યેશભાઈ 2 જણા મનીષાબેન દિવ્યેશભાઈ 2 જણા આગળ બેન તમારું નામ બોલી તમારું નામ રમેશ નામ કે એસકે વરાભાઈ પછી પીજી ગોહેલભાઈ પછી બીજી જોડિયાભાઈ પછી અમિતાબેન સિપ્પી કેતનભાઈ પ્રવીણભાઈ 5 જણા કેતનભાઈ પ્રવીણભાઈ 5 જણા કેતનભાઈ 5 જણા
ચલાવવાનું કોણ
પિતાજી હતી સાંભળો આમાં અમે સાહેબ એક સંલગ્ન કેસ છે 306 નો અમે એમાં ફરિયાદી વધી હતા ઈ કેસ નીચે ચાલુ છે તો ઈ કેસ ની મેં નકલ વાગી ને સાહેબ એ જે મેં નથી કરી ચાર્જશીટ ને બધા પેપર
ડોક્યુમેન્ટ રજૂ કરતો તો હું એમને કાઢી નાખવા જે દિવસે ડોક્યુમેન્ટ મારા પાસે કોઈ એક્સ્ટ્રા મૂકે એટલે એના અંદર જે હોય કરી નાખે નકલ જેટલી માંગતો હોય તો પછી નકલ રજૂ કરતો લોચા પડી જશે રજૂ જે બી કરશો તો પછી બી
શું નામ ભાઈ તમારું તમારું નામ ભાઈ તમારું નામ બેન આત્માબેન અશોકભાઈ ટપ્પુભાઈ 4 જણા અશોકભાઈ 12 બેન અશોકભાઈ ટપ્પુભાઈ 4 જણા ભક્તિસિંહ કેજે જાડેજાભાઈ વનિતાબેન અશોકભાઈ ટપ્પુભાઈ અવનસિંહભાઈ દીપકભાઈ ધીરજસિંહ
10 વીઘા જેવી ચલાવો ચલાવતું ડિસ્કશન પંચમાં આવું જે આવે છે
અશોકભાઈ અને ધીરજભાઈ આ એક અને ચાર છે એને verify કરવાનું છે.
કયા નંબર એક અને
અશોકભાઈ અને ધીરજ
કોણ કોણ છે હવે
અશોકભાઈ અને ધીરજભાઈ
તમારો વકીલ નથી
ના વકીલ હજી નથી કંઈક હાઈકોર્ટમાં જવાનો વિચાર છે ક્રોસિંગમાં જવું છે
હા
એટલે
તો પછી કોચિંગમાં તમારે અલગ જવાનું ને અહીંયાથી ચલાવવાનું ને કઈ કે હે તમને સરકારમાંથી વકીલ આપો છો લઈ લો એમ કે તમે તો વકીલ રાખવાના નથી
ના રાખી લે એક મુદત આપો તો હવે આગળ વખતે રાખી લે
છ આઠ વકીલ શ્રી કે એમ મહેતાભાઈ વકીલ શ્રી એન કે આચાર્યભાઈ વકીલ શ્રી ડી એમ શાહીભાઈ વકીલ શ્રી અમિતાબેન સિક્કી વકીલ શ્રી બીજી ધનકારીભાઈ એજાજ અકબરભાઈ વિગે 11 જણા એજાજ અકબરભાઈ 11 જણા એજાજ અકબર 11 જણા
ના વકીલ છે
બધાને 10 નંબર ના સાક્ષી છે
10 નંબરના
સાક્ષી છે માજીદ સુલેમાનભાઈ
વકીલ કોણ છે
4 નંબર વકીલ કોણ છે ભાઈ
આ 10 નંબર
ઇમરાન જમનદાસભાઈ
પાછળ ઉભા રહો, પાછળ.
માજીદ રફીકભાઈ
હવે આ કોણ છે આ નામ તો
રિજવાન
રિયાઝ ઇસ્માઇલભાઈ 6 નંબર છે
6 નંબર
રિયાઝ ઇસ્માઇલ હા તું અરજી કેમ કરી હતી આ અરજી શેના માટે કરી હતી લાવવાની કોઈ જરૂર નથી હવે ઓનલાઈન થાય છે રોજ રોજ કેમેરામાં આવો છો ને તમારો વકીલ ચલાવે તો ને એમને ચલાવો જ નથી તમારો કેસ તમારો અલગ કરી દો અલગ કરી દો ભાઈ એનો 299 ઓર્ડર કરો એને વી સેપરેટ થાય ઇફ ધી અધર્સ આર નોટ વર્કિંગ બધા વકીલોને બોલાવી લેજો ભાઈ જેના જેના હોય I will because the others don't want to go ahead with the trial and આ ભાઈ અધર્સ નંબર કોણ છે
6 થી 8 અને 10 નો છે ને એ લોકો રિસીવ તમારે સરકારી વકીલ છે
અધર્સ નંબર તો યુપી જ નથી
એમાં પછી
10 થી 8 તમે
બિલકુલ છે ને
7 8
એટલે 10
10 નંબર
કઈ મુદત
છમાં કોણ છે
6 મહિને
તમે જ છો
6 7 8
6 7 8 10 બીજા કોણ છે એમાં
બધા થઈ ગયા આઈડી બધાઈ
ચાલો બધાને તમારો આજે ચાર્જ ફેલ કરે તો ચાલુ કરી દઈએ ઠીક છે તો પછી હવે શું રહ્યું છે
પુરાવા માટે
ચાલુ કરો મને બોલાવો
ફરિયાદ
બોલે લો ક્યારે બોલાવો
Rejected, right, okay.
એ આવશે કે ના આવે અર્થ બંધ કરી દો ક્રોસ કરવું જ નથી તો શું કરી આપે
12478
1
12478 એના applicability હતા જે તે તમારે પછી અમુક આવી ગયા હતા
એક બે સાત આઠ અને આપણે ઇન્ટરવ્યુ કહી દેતા ને
હા
જેલ માટે બીજા ગુનાના કામ
બસ તો પછી
એની હાજરી લઈ ગઈ છે. ચાર પછી 5 નંબર ઇમરાન જમનાદાસભાઈ ઇમરાન
ઇમરાન જાનનો
જામ મોહમ્મદ
બધું ગુજરાત ઈ આપી દીધું
માજીદ રફીકભાઈ
બીજા તારે
મુસ્તફા અકબરભાઈ
નોન અવેલેબલ કરनी નોન અવેलेबल करना चलो यार बोलो अच्छा लीज कर तारीख बीजा रूम में रखवाना
और August 9 May 5th or 6th. When you are done,
I want to start.
I don't have any. The 5th or 6th would be better, and the summers would not be served in 2 days. The complaint.
You will call him.
I will call him, but we'll have to prepare him. It's Monday or Tuesday.
And let him be account. He is what it will be.
Normally it is here.
He will be ready with it. Google it.
Monday or Tuesday. We'll call him.
Monday.
Tuesday, 6th.
Now, if you love it, not love it, doesn't matter.
સાહેબ નંબર 1 ફરી
Here. We'll start with complainant. Panchayat would be only arrest Panchanama, etc.
જવાદાર હવે એમને લાવવાની જરૂર નથી હવે 6 તારીખે તમારો કેસ ચાલી જશે
અને બાદ બેસાડો 6 તારીખે તમારો કેસ ચાલુ થશે તમને લીખિતથી આમાં ઓનલાઈન કરશું કનેક્ટ કરશું હો
અને ફરિયાદી આવશે એ દિવસે વકીલ આવી ગયા સરકારમાં બધું પતી ગયું છે હવે ફરિયાદી આવશે 6 તારીખે ચલો લઈ જાઓ અમને
अच्छा સરફરાજ ગુલામ નબી વગેરે 5 જણા
કોઈ નથી નોન ડિલિવર વન કરે એક નંબર યુટીપીસી
આઈસી સુરત આજે
બીજા બધા
નહીં લેવું
બધા બધા નથી આયા બધા નોન ડિલિવર કરે ગાય લઈ ગયા
શાહરુખભાઈ હનીફ મિયા,
શાહરુખ હરીફ મિયા,
અકરમ ઇકબાલભાઈ,
અકરમ ઇકબાલભાઈ,
સોહિલ જમાલભાઈ,
સુરેશ જમાલભાઈ,
ત્રણ જ થઈ ગયા. ખાલી ત્રણ જ થઈ. ચાર છે. બીજું બસ. Yes. અને એને વીસ જેને ચાર્જ લેજો. અને પછી રોજ તમારે કે બીજા હાજર ના હોય કે એને વર્ષ કરે.
બે લાખ છે પછી આવવાનું.
હા, એટલા માટે તો નોંધ લેવી કાઢી દીધી.
એક નંબરથી સ્ટુડન્ટ જેલમાંથી બાકી બધી સમજ
નોંધ વેલો તો કાઢી દીધું. તમારે જે ના મને શોર્ટ જ રાખો. I want to fill the charge.
હા, એવું જીવન પ્રાપ્ત થાય, એવું જીવન થી everything.
એ પણ કરી શકીએ, કરી શકાય. એ પહેલા લખાઈ દીધું. તો વર્ષની અંદર આપણે ચાર્જ માટે આ લઈ લઈએ છીએ. રાજકોટ અરે સુરત જેલમાં.
બીજાના
બીજા બધાના invitation. પછી એમના 82 ના પછી હમણાં તો એલબીડબ્લ્યુ કાઢી દઈએ એકવાર અને ચાલુ કરી દઈએ. કેટલી વાર છે લાસ્ટ ટાઈમ આવ્યા
બે રીતે એના તો લાસ્ટ બે જ નિરાશ થઈ
સૌની છે ધોરણ કદાચ કરીશું process કરીશું.
નોન વેલેબલ
મંગેલે બધું સર્વિસ એજન્સી વિલ ટેક સમ તેના પછી નવી ફારા કે કોર્ટમાં એટલે બીજો ક્લોઝ કરી દે. We will see that warrant is done in the meantime. કોર્ટમાં.
પોતેશી આર કોટેચાભાઈ, પોતેશી આર કોટેચાભાઈ, પોતેશી બીલી માકરિયાભાઈ, પોતેશી જીએસ સુરૈયાભાઈ,
હાઈકોર્ટના હુકમ મુજબ પેમેન્ટ કરવામાં માટે આપે છે અને એમાં વીમા કંપનીને અમુક રકમ પરત આપવાની એકાઉન્ટ નંબર આપવાના
આપી દઉં છું. Xerox
ચલો
હાજી
પોતેશી એમએસ પરમારભાઈ, પોતેશી એમએસ પરમારભાઈ,
સુરેશ પરમારભાઈ,
પોતેશી એમએસ પરમારભાઈ, પોતેશી એસજી ભાવિશજીભાઈ, પોતેશી એજે પોપટભાઈ, પોતેશી એજે પોપટભાઈ, પોતેશી એજે પોપટભાઈ,
Screen.
પછી એમએચ પરમારભાઈ, પછી જીએસ સુરૈયાભાઈ, પછી જયદીપ દ્વિવેદીભાઈ. 15
હું આ તો આપવાની છે.
લાસ્ટ ટાઈમ એમને શું કીધું હતું? પેલા ડોક્ટર ને બોલાવવા માટે અરજી આપવાના હતા.
આ તો બધા અસલ ડોક્યુમેન્ટ છે ને, એટલે ઓરિજિનલ છે એટલે તે પણ એમણે એમ કીધું કે બીજા છે ને માતાજી અને ડોક્ટર તપાસ અમદાવાદના ડોક્ટર મેડિકલમાં હોય તો આપણે કીધું કે અત્યારે અહીંયા જોઈને શું કરવું છે. હું છે ને ઓરિજિનલ કરેલા છે ગવર્મેન્ટ હોસ્પિટલનું સર્ટિફિકેટ છે એને આ આપવા માટેની અરજી આપે અને એની સાથે નામદાર સુપ્રીમ કોર્ટનું જજમેન્ટ પણ કે અહીંયા જે પેપર રજૂ થયા હોય એને આ ન હોય તો નામદાર ટ્રિબ્યુનલ કન્સિડર કરી શકે અને અહીંયા તો સાહેબ હું ઓરિજિનલ પેપર રજૂ કરું ના અમુક એવા ડોક્યુમેન્ટ છે જેને હાથ ન પડ્યા હોય ઇવન તેની યોજના એમ્પાવર ના કરું એટલે હું આપણું નથી એટલે આ લોકો વાંધો નહીં હું અરજી આપું હું વાંધો શું
આપણે ફરીવાર યાદ કરાવું કે આ કેસમાં કેસ ઓફ સિમ્પલ ઇન્જરી 1.5 વર્ષ સુધી પછી કોઈ સારવાર નથી. ઈ પછી એ લોકોને એને મેન્ટલ તકલીફ હતી છોકરી ત્રીજો થઈ ગયો એના માટેનું ડિસેબિલિટી 80% લઈ આવવાની એવું કહેવા માંગે છે. આ એક્સિડન્ટલ ઇન્જરી નામદાર ટ્રિબ્યુનલે વચગાળાના સબૂતે 2 પક્ષકારોને એટેલેન્સ સાંભળ્યા પછી એવું ફાઇન્ડિંગ આપ્યું છે કે આ જે સર્ટિફિકેટ છે એ પુરાવાનો વિષય છે અને એના લીધે નહીં નથી કરી શકે. આ બદલા તેના
ઓર્ડર થઈ ગયો છે
હા તો વચગાળાનો એવો ઓર્ડર થયો છે એટલે ફરી વખત સાહેબ મને આપતો આ બધી રજૂઆત મેં આપને કરી હતી. પછી એને એમ કીધું સારું તો હું સાહેબ આવતી વખતે એ જે ઇસ્યુ કરનાર ડોક્ટર છે એને હું તપાસવા માટેની અરજી આપું છું અને એ દિવસે એને આપી.
મારે સાહેબ તપાસ વખતે નથી એ તો બરોબર આ ગાડીમાં
is not there તો પછી
ultimately
he doesn't file an application why should we insist on him કે આ લાવું એટલે now one order is there one order is there already
એમાં સાહેબ નામદાર કોર્ટ એવું કહ્યું કે પ્રાઇમા ફેસી વી કેનોટ હોલ્ડ એટલે સિરિયસ કનેક્ટ નાઉ સર આઈ હેવ સબમિટેડ ઓલ ટુ મેડિકલ પેપર
but then
then your own have to decide અને સાહેબ આ છોકરી તો માર્કશીટ જોશે એક્સિડન્ટ વખતે નોકરી પર જતી હતી જો ફેરિયાની કોઈ તકલીફ જ નથી રિક્ષામાં જ સાહેબ બહાર ફેંકાઈ ગઈ એને માથામાં ઈજા થઈ છે માથામાં જે અંદરની ઈજા હોય એ તો આપણે હું આપણી છોકરીને પણ હાજર કરું સાહેબ આપણું સી ઇઝ ટોટલી ઇનસેફ
if they are
It is
that is okay
Exactly.
if they are not related we leave it
આજે આપણે ડિપેન્ડ હું આપણે ઓકે
sensitive 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 આંખ આપું છું કામ ચલાવો
પછી એમ
Of the each of the FIR, please turn to para 29. That is the first FIR, Roman 141 of 2016, which is recorded on June 19, 2016. Please turn to page 100. The order passed by this Honorable High Court granting me anticipatory bail.
What happened in that case? Trial ચાલુ છે?
છે ને? અને અડધી ટ્રાયલ ચાલુ થઈ ફરિયાદી આવતા નથી.
ના ના
આ સેશન મોડલ
કેસનું કેસ.
સેશન્સ કેસ અડધી ચાલી પછી ફરિયાદી આવતા નથી કારણ કે પુરાવો તો કઈ છે જ નહીં. 5.5 મહિના ફરિયાદ મોડી છે. ડેડ બોડી મળ્યા નથી. અને 4 મહિના સુધી પોલીસ સ્ટેશનમાં એવું કીધું છે કે મારો હસબન્ડ જીવે છે, મારો પતિ જીવે છે, મારા પતિને કઈ થાય નહીં. FIR ની કોપી છે મેં મૂકી છે. Page 90. I'm not named. Shailesh Chandu. No, I'm named. Munna Bhai. અને તેના મળે એક કોપી 94 નંબરના પાના પર વાંચવા જેવું છે. લાસ્ટ रहेगा. આથી 2.5 કલાક ગુજરણ ગામે ભરતના અજીત કાઢીના ફોન મારા પતિ ઇમરાન અને અમારા આખા કુટુંબના કુલ 10 સભ્યો ડર્યા અંગેની ફરિયાદ છે. This is ગૌરક્ષક who have been murdered by this person. મારા પતિ ઇમરાન ગયા મોહરમમાં મહિનામાં કે આથી 6 મહિના પહેલા જેલમાંથી 21 દિવસની પહેલો છૂટેલા. ગંગરાવના બનાવ બાદ હું તો તમારા સાસુ અહીં કરજાળા ગામે મારા પીજીના ઘરે રહેવા છે. અહીં ઇમરાન આવેલ ને પહેલો કરી જેલમાં હાજર થયેલ નહીં બહાર હું તો અવારનવાર રાત્રિના કરજાળા ગામે મળવા આવતો હતો અને મને વાત કરતો કે કાઠી સમાજ મને શોધે છે, બદલો લેવા માટે મારી વોચ કરે છે. દોલતી ગામ વાળો શૈલેષ ચાંદુ અવારનવાર તેનો પીછો કરતો હોવાનું મને વાત કરી હતી. તારીખ 10/4/16 રાત્રિના દોલતી બમ્પર ગામ વચ્ચે બનેલ બનાવ મારા પતિ ઇમરાનનો મોબાઈલ ફોન મોજડી જતા પિસ્તોલ કાઢી મળી આવે છે. વાહન અકસ્માત જેવો બનાવ બને અને લોહી પડેલ જેવો મોટરસાયકલ કરજાળા રફીક રૂમાલનું સોંજો કરવાનું હતું નહીં. આ બનાવના સમાચાર છપાવતા અમને જાણ થતા હું અને મારા સાસુ ઉમરભાઈ અને અમારી જ્ઞાતિના પ્રમુખ સોયંચો તથા અમરેલીના એડવોકેટ સોયંચો સાવરકુંડ લાવેલ અને સાવરકુંડના રોહિત પોલીસ અમારા પતિનું અપહરણ કે હત્યા કરી નાખેલ હોવાની દહેશત હોય તપાસ કરવા અરજી સ્વરૂપે એક આવેદન પત્ર આપેલ હતું. બાદ રફીક બાપુભાઈ ઉમરાભાઈ જ્યાં બનાવ મળેલ તે જગ્યા જોવા એટલે આવીને મને વાત કરી કે રોહિત ઘણું બધું નીકળી ગયું છે. આજ દિન સુધી મને ભરોસો છે કે મારા પતિ ઇમરાન હિંમત વાળો છે ને નીડર હોય તેને કઈ થયેલ નહીં હોય તેવું હું માનતી હતી. પરંતુ આજ દિન સુધી ઇમરાનનો કોઈ ફોન કે સમાચાર મળેલ ન હોય તે જીવિત હોય તો હજુ મારો સંપર્ક કરે. તેથી 10/4/16 દિવસે કરજણ રફીક શેખના મારા પતિ ઇમરાન દલ અને ઇમરાન પેરોલ પર આવ્યો ત્યારે તેની સાથે રહેતો. ઇમરાન સાથે ભાવનગર રાધે બાવાજી ત્રણેયને કાઠી સમાજે બદલો લેવા માટે ગમે તે મારા પતિની સિક્રેટ ફાયરિંગ કરી તેને કારનાકી પૂર્વક નાશ કરી તેને લાશનો કોઈ પણ નિકાલ કરી નાખ્યો. હવે ધીસ ઇઝ ઇન્સિડન્ટ ઓફ 10/4 અને FIR કરી છે 18/6/19. Where I was granted anti-bail by the High Court. Order is based from 100 to 108. Second FIR on page para 29, para 30, page 29. Page. Second FIR is referred to on para 33, page 30. That is CR number 10 of 2016, 186,114. લોકો એટલો બધો નથી. FIR મળતી નથી કશું જ નથી. Third FIR refer કરી છે page 31 para 34. Roman 2, 9 of 2019, Arms Act. Laws on March 16, 2019. Next D. Fourth FIR 21 of 2019. Sorry. 21 of 2019. Annexure E is 116. अच्छा. 17 March 2019, yes. 16. Instead of 16, it is accorded to 7. Page 118. એક માંથી 3 FIR કરી છે. એક જ બનાવની 3 FIR કરી છે. એક પીવાની, એક દારૂની બોટલની અને એક રમકડાની મૂર્તિ. પાસે 3 FIR માં લખાઈ દે આ બનાવવા છે. Please turn to page 126, 127, 128. May not read it. Do not read it. મારે ત્યાં આવ્યા તલવારો તો અમારી બાપ દાદાની મિલકત છે. બે તો એન્ટિક તલવારો છે. જેની કિંમત લાખોમાં છે. My great grandfather was the જાગીરદાર. આટલી ઘરે તલવાર જ. માં તલવાર ન રાખવી એવો હજી સુધી કોઈ કાયદો ઘડાયો નથી. જાહેરમાં લઈને ના નીકળાય એ વાત જુદી છે, પણ ઘરમાં ના રાખવી, પબ્લિક પ્લેસમાં ના લઈ. તલવાર રાખી, રમકડાની બંદૂકનો એક ગુનો, એક બોટલ દારૂનો બીજો ગુનો, અને પીધેલો નથી. Both facts have been narrated in para 35, 36 and 37. All three FIRs in America. Now very important on page para 38. This I'll read this paragraph is important. So this is where I've been arraigned as an accused. The accused number one stated that one more FIR is lodged against the accused number one in the Auto Police Station of Ahmedabad City, which is recorded prohibition case number 359 of 2019 for the offenses punishment section 66 1B, 65 AA, 85 1, 84 C, 81, and 84 of the there is a wrong, so it should be the prohibition act. This is the offense. Annexure G 130. It is against three persons. Arpal G. Sarvaiya, Gautam Bhai Kumar, and Shivraj Vichya. I am the accused number three. And Usha. There are four accused. Usha Danga. Chronology page 113. Sorry, 133, not 113. Tenth line from the top. બોટલ પંચો રૂપો ખોલતા અંગ્રેજીમાં 100 લખેલું છે. જે બોટલ જોતા તેમાં 200 મિલીલીટર જેટલું રંગીન પાવી ભરેલ છે. જે બોટલને કલેક્ટર દારૂની તીવ્ર વાસ આવતી હોય, કાચની બોટલમાં બાટલીની ત્યારે પેટ્રોલ પંચ હશે. 200 ml દારૂ.
133.
133. FIR is 130. 10/12/19. આ ગુનામાં હું ગુસ્સી કોર્ટમાં છું. 200 ml દારૂ 4 જણા હોય. બાકી બધા જ ઓફેન્સીસ છે એ પ્રાયર ટુ ડિસેમ્બર 1, 2019 છે. ને 7 FIR મારી સામે જે દુષ્ટિ કોર્ટમાં રિલાય કરે છે એમાંથી 5 પ્રોહિબિશન હતી, એક આર્મ્સ એક્ટ અને એક મર્ડર છે. मैं क्या टेररिस्ट एक्ट है और क्या ऑर्गेनाइज क्राइम एक्ट है. પોણા 2 વર્ષ જેલમાં છે. હવે 7 FIR માંથી એકની 3 કરી છે. In that, Your Honor will find the complete narration on page 33 of my petition. There are 37 on page 32. Your Honor, permit I'll read. The accused on the state one more FIR lodged against the accused number 1 in police station under section 24, section 7. So it may be noted the later point of time, more sections have been added. It is pertinent to note that the said offence is registered against one Mr. Natubhai Kumar. It may not be incompetent to point out to this honorable court that the personal grudge of Mr. Nirlit Rai has commenced herefrom. The raid was allegedly carried out at the premises of the co-accused Natubhai Kumar at village Senjal, Taluka Sarakunda, district Murray. At the time when the only woman members of the family of the said accused were present. Family of the said accused were present. Raid was carried out. Certain arms allegedly have been recovered from the premises of the said co-accused. The FIR is lodged on August 1, 2019. The allegations made against accused number 1 is that accused number 1 has harbored the said accused, and therefore accused number 1 has committed offence under section 212 of the Indian Penal Code. So one offence is of harboring. This is what kind of the involvement mine is. Now, I have given a narration of the details on page 34, para 40. One paragraph I'll read it for you. The accused one said that the FIR has been lodged in Sarpana police station, which is recorded Roman number so and so. For the offences punished under section so and so, so and so. This is what the first information of the police is. First informant is the police officer. From copy of this copy supplied to the petitioner, it is evident to the first that first informant is a NR Karamta, in charge police inspector of the local crime branch, has submitted typed copy of the FIR dated so and so. The said FIR is lodged against 9 persons. The accused number 1 is shown as the accused number 1 in the said FIR. The accused number 1 is stated to have been involved in 8 criminal cases, which are from year 2016 to 2020. Out of the 8 cases referred to in the said FIR, 4 cases, the prohibition number 21 of 2019, lodged with the Jessel police station. Prohibition case number 24 of 2019, lodged with the Jessel police station. Prohibition case number 255 of 2019, lodged with the South Kunda police station. And prohibition case number 529 of 2020, lodged with the Auto police station, Ahmedabad, are in relation to prohibition offences. In case of the prohibition offense 21 of 2019 and CR number 9 of 2019 recorded, the Jessel police relates to the one transaction. એકના જે કરેલા છે. Out of one transaction, two separate offences have been recorded. In case of so and so laws with the Jessel police station, no prohibited arms have been found from the premise of the petitioner. Air guns are not prohibited firearms. And therefore, though the offence relates to dated so March 16 to 19, more than 1 year has gone, no charge sheet has been filed in view of the fact that when the accused number 1 was produced before the learned magistrate, the concerned police officers were reprimanded by the learned magistrate, pointing out that police officer must know his limits. The FIR relates to Savarkunda police station number so and so. The accused is enlarged on intercepted bail by the Honorable High Court of Gujarat, that is the 14 of the triple murder. Since there is no, so far as the prosecution is not in position to produce any tangible evidence against the accused number 1, so as to connect the accused number 1 with the alleged offence. Therefore, out of the 8 offences, so far as 141 is concerned, the accused is falsely implicated. Said facts were very well known to the respondent. At the base of Mr. Nil reply, Sergeant of Police of Bhavnagar district raided the premises as accused number 1 and found nothing incriminating against the petitioner. Still, however, accused number 1 has been arraigned as an accused in prohibition cases and in case of the firearms. Be it may, out of 8 cases referred against the petitioner, accused number 1 is charged for the offences punishable under section 212 of the Indian Penal Code in CR number so and so, recorded in Vanda police station. So far, the CR number 20 of 2016 recorded in Bagdana police station is concerned. Accused number is charged for the offences punishable under section 186. The police has no power to record the FIR in case of the offences punishable under section 180 of the code, and that is the central law settled by the FS Court and the Honorable High Court of Gujarat. Therefore, out of the 8 cases referred to against the petitioner, 4 cases relate to prohibition, 1 relates to destroying the disobeying the authority passed by the competent authority. 2 offences relate to 1 incident, and 1 is prohibition case, and another is the firearm. Therefore, Mr. Nilip Rai has made out a mountain out of a mole. In the body of the FIR, history of the co-accused have been given. However, in 8 offences referred to the FIR, wherein accused number 1 is stated to be involved in the said offences, it can never be said that the said offences have been committed either as a member of the organized crime syndicate or on behalf of the organized crime syndicate. Incidentally, one of the accused is co-accused in the case of the offences alleged against the petitioner, which according to the first informant of the those FIR have not been committed in any stretch of imagination, individually as a member of organized crime or on behalf of the organized crime. Copy of the so and so is. So this is my sum and substance of the case. Now, Lord, please turn to paragraph 41. Why this has been done. This Natuba was one of the leader of a community of party. We have no criminal antecedent. But as I'm making the serious statement that Mr. Nilip Rai took a public oath that he would beat 1 kathi every day. And he was doing it personally. SP. I made him a party in the High Court, joined by name, and he has not dared to file affidavit. Denied this right. The accused number 1 said that the FIR being so and so lodged with was registered with the against Natuba Kumar and 2 others. Said Natuba was arrested by the police inspector of Rajula police station on October 12 at midnight. The possession of the Natuba was taken by the Vanda police station next day, that is 11:30 AM on October 13. Kumar was directly taken to the office of the Superintendent of Police at Amreli. Mr. Kumar was kept in the office of the LCB. Mr. Kumar is a heart patient. Kumar is suffering from the hypertension. Blood pressure of Kumar on several occasions is as so low, which endangered the life of the Kumar, and therefore Kumar is under the medication. Mr. Kumar was assaulted by Superintendent of Police on his face. Kumar was assaulted by the Superintendent of Police himself, who had given a fist blow on the face and on the chest. the Supreme Police was specifically informed that Mr. Kumar may not be assaulted on the chest since Mr. Kumar is a heart patient. Supreme Police was not ready to listen. Kumar listened Mr. Kumar and he gave multiple blows in the face and on the chest. Kumar suffered an almost puncture wound on the cheeks of Mr. Kumar, which was causing severe bleeding. Bleeding could not be stopped, and therefore, Superintendent of Police was alarmed, and he first ordered to close CCTV cameras of the entire office complex. And thereafter, Mr. Kumar was taken to the doctor, initially to the clinic of the Garup. However, he could not stop bleeding from the injury of Mr. Kumar, and therefore, Mr. Garup suggested that Mr. Kumar should be taken to the surgeon. Mr. Kumar was taken to the surgeon where the injury was stitched. However, Mr. Kumar does not know the name of the doctor. The accused number one said that Superintendent of Police realized that he could not have caused injury which was severely bleeding, and therefore Superintendent of Police was alarmed and was sending message to Mr. Kumar that while Mr. Kumar is produced before the learned magistrate, no complaint should be made before the learned magistrate of a custodial activity. Mr. Kumar refused to bow to the request made by the police officer, and therefore the request was turned into a threat. Mr. Kumar was informed that if Mr. Kumar dares to complain against the Superintendent of Police, he will have to face the music of the false involvement in serious offences. Mr. Kumar informed the police officer that Mr. Kumar has not committed any crime, and therefore question of assaulting by the Superintendent of Police would not have arisen, and therefore it is matter of personal liberty of the Kumar which is assaulted by the Superintendent of Police, and therefore Mr. Kumar would make complaint before the learned magistrate. Mr. Kumar was threatened time and again, and ultimately Kumar was taken to the Vanda police station, where, as per the information show, Kumar is subjected to the confirmation. But otherwise, by respondent was arrested on 8 p.m. on October 13, 2020. Mr. Kumar was produced before the learned magistrate, first class Halkund at 6:10 p.m. And Mr. Kumar was produced before the learned magistrate after lapse of 42 hours for the first time in the arrest of the subject. The petitioner stated that Mr. Kumar had in detail narrated about the police atrocity in the custody. The learned magistrate recorded the complaint of Mr. Kumar, however, copy thereof is not given. This is what we want, we have to withdraw, which we refused, and therefore we are facing this music. This is most malicious. Even today, my names are being involved. And police officer is there only. It's not the IO. It's not the IO. SBI even know say. This kind of allegation that you I have placed before the writ petition before the High Court for holding an inquiry where the reply is party. What is happening? But what is happening? It's pending. Yes, the government is not coming forth. Nobody reply is being filed. These all facts were placed before the Honorable Supreme Court. There should be a limit of the police atrocity. We granted the bail. And bail this was placed. You should have taken some observation regarding this. Affidavit no? Supreme Court પાસે કઈ observation લઈ લેવા હતા ને? I can't advise the Honorable this kind of things. This all are used. Supreme Court was ready to quash the but that what is transfer is to become for information. It can't be subject matter of discussion. But I am not saying something which is I'm not placing in black and white. I'm not going beyond my pleadings. And this is not the first time I'm saying it. Prior to Gusti Court petition was filed. It's not that after Gusti Court petition was filed. Gusti Court is the file is outcome of my filing a writ petition before the High Court. That Kumar's writ petition before the High Court. Yes.
So this is how,
Isn't that which case this is? Some other case. This is in some other case.
this engine is wonderful, where I have been shown as the arbiter, 212. I am accused. એનો એલિગેશન એવું હતું કે મેં એને 4 દી મારી વાડીએ રાખી હતી. તો સાહેબ 4 કેસમાંથી 4 પ્રોહિબિશન ના, એક હાર્બરિંગ, એક ના 2 કર્યા, ને 3 છોડાય. આમાં ગુસ્સી થાય તો મને ફાંસી કરાવી. Now in this background, actually I almost completed, I am not requiring every document. I would like to rely upon 2-3 judgments. I have cited number of judgments, but would bother to point out only 2 things. This I think on your honor would look into it. આવું વોલ્યુમ પણ મેં આકૃતિ છે ભાઈ, આવું એક વોલ્યુમ સેપરેટ ચાર્જશીટ નું પણ એ આપકો રેકોર્ડ જ નથી થતો.
Photo actually search करे. So
મળી જાય તો હું બતાવી દઉં. સાહેબ I have placed it on record for your honor's consideration.
એક્ઝિબિટ વાળું છે કે એમ જ આવી ગયું? એ એક્ઝિબિટ સાથે છે કે એમ જ છે ઓલું?
મારી પાસે એક્ઝિબિટ નથી. નહીં,
હા
તો તમારું ઓરિજિનલ હતા.
ચાલશે એવું નથી.
સાહેબ જોવું ના પડે ને એટલે મેં આવું. Please turn to Mokoka. By and large, the language is the same. To A, abet, the same things, same language. D, continuing on unlawful activity, almost same. F, organized crime. Syndicate, organized crime syndicate means a group of 2 or more persons who acting either singly or collectively as a syndicate or a gang, including indulge in the activities of organized crime. So almost same language. આમાં ટેરરિસ્ટ એક્ટ નથી થયું, આમાં ઓર્ગેનાઇઝ ક્રાઇમ છે. Means continuing any continuing unlawful activities by individual, singly or jointly, either as a member of organized crime syndicate or on behalf of the candidate, by use of violence, threats of violence, intimidations, coercions, or other unlawful means, with object of gaining pecuniary benefits or gaming undue economic or other advantage for himself or any other persons, or promoting insert such. This is like definition. Section 3 says who commits an organized crime.
મોકોકામાં તો extortion બી નથી.
Pardon?
મોકોકામાં extortion નથી.
No.
Extortion, land grabbing,
નથી, extortion નથી,
economic offenses,
એ નથી, પછી gambling નથી, prostitution નથી.
threatening of
It is
the
only economic
economic
advantage. This is more,
it's a lighter,
okay, later.
lighter than. Still, what the bench of the
It will tell me.
first I would like to rely on Jitendra Thakur. Yes, yeah. Nineteen Supreme Court.
19.
1994, 4 SCC, page 603. 1994, volume 4, SCC, page 603.
This is Thakur. This is Thakur versus.
Jitendra Thakur versus State of Maharashtra. Fellow volume.
I don't have the copy, but we can read. Okay.
Para 1. Page 615. In this batch of the criminal appeals and special petitions, the three meaningful questions which require our consideration are: when can the provision of section 3(1) of the Terrorism and Disruptive Activities Prevention Act 1987 refer to the TADA? Is 1993 amendment amending section 167 to the code of the criminal procedure code by modifying section 24B and adding new provisions of 24BB applicable to the pending cases, that is it retrospective in operation? What is the true ambit of section 24 and 28 of the TADA in the matter of grant of permits to the accused? These are the issues raised before the Honorable Supreme Court. I would like to read certain paragraphs in which internal, the page 632, 622, para 30, para 1. We would therefore at this stage like to administer a word of caution to the designated court regarding invoking provisions of TADA merely because the investigating officer at some stage of the investigation chooses to add an offense under the state the provision of TADA against an accused person more than often while opposing the grant of the bail anticipated otherwise. The designated court should always consider carefully the materials available on record and apply their mind to see whether the provision of TADA are even prima facie affected. Then next page 623, 6 and 7th line from the top. An onerous duty is therefore cast on the designated court to take extra care to scrutinize materials on record and apply their mind to the evidences and the documents available with the investigating agency before the charge sheeting the accused for the offense under the TADA. The stringent provision of the Act, coupled with the enhanced punishment prescribed for the offense under the Act, makes the task of the designated court even more onerous, because the grave offense, the greater should be the care taken to see that offense must strictly fall within the four corners of the Act before the charge is framed against the accused person. When the designated court, without as much as even finding prima facie case on the basis of the materials on record, proceed to charge it and accuse under the provision of TADA, merely on the statement of the investigating agency, it acts merely as a post office of investigating agency and does more harm to beat the charges arising out of the terrorism activities rather than deterring terrorist activities. Remedy in such cases would be worse than the disease itself. And the charge against the state of misusing the provision of TADA would gain more acceptability, which would be bad both for the criminal and the society. Therefore, it is obligations of investigating agency to satisfy the designated court from the material collected by during the investigation, and not merely by opinion formed by the investigating agency, that the activity of the terrorist falls strictly within the parameters of the provision of TADA before seeking charges on the accused under the TADA. Have you guys have questions?
Yeah,
There is 623. Page 623. I was reading from 1, 2, 3, 5, 6, 7th line. I said, the owner's duty is therefore cast on the designated. You know what? Yes. The designated court must record its satisfaction about the existence of the prima facie case on basis of the materials on the record before it proceeds to frame the charge sheet against the accused for the offence covered under the TADA. Even after accused has been charge sheeted for the offence under TADA and the prosecution lead evidence the case, it is obligation of a designated court to take extra care to examine the evidence with a view to find out whether the provisions of the act apply or not. Designated court is therefore expected to carefully examine evidence and after analyzing the same, come to a firm conclusion that the evidence led by the prosecution has established the case of the accused falls strictly within the four corners of the act before recording conviction under the accused under the TADA. Then please turn to page 624. But the crime was not committed with the intention as envisaged by the so and so to achieve the objective as envisaged by the section. The accused should be not convicted for the offence under so and so. To bring home the charge under section 3(1), the terror or panic, etc., must be actually intended with a view to achieve the result as envisaged by the said section, and not merely an incidental fallout or consequences of the criminal activities. Very important.
I reported
Then
during China time.
this is relevant. Then let's come to the next judgment. Pratap Singh. Chief.
Really tied out or
Same line. I may not bother. First off, because you have more experience in Tata than
Maybe I want a judgment on this,
which
the word and.
And.
Yeah.
Yes.
And also in my thought.
of. Is it convicted? Not this thing.
That is more relevant.
Yes. I'll find out the question.
Because both these judgments, Jitendra and Kartar would only be applicable if you show that both and is required. Because unless and until you show that somebody, then either in this both judgments will become non-applicable if there is only one thing required to be proved of person. It is
No judgment is required on this. I'll tell you why. Simple answer. Article 20, Article 1. Act must be act defining as an offense. The continuing unlawful activities permitted prior to December 1, 2019, which is not act.
the next stage is that
That is,
this
that,
and prior.
but that cannot be.
Then you have to challenge the
No, but it is interpreted in Bharat Chand case. All these judgments are on that point. And I am referring to judgment of the Supreme Court.
So the act will
Which-
never be challenged.
Yes, yes.
If somebody would have challenged the act, then it's
It is challenged, pending, it is pending.
it come under the control. Now, I cannot go into that. See.
No, no, but I can only argue to the contrary.
Unlawful activity and terrorism.
Yeah.
So there are two things. Terrorist, Jitendra and Kartar falls when comes in when terrorist is. What happens for Andhra? Ek lama.
The full bench of the Bombay High Court has answered.
But then Bombay High Court would not answer. They would answer only Mokoka. I say we need a judgment of the Gujarat High Court.
Judgment आएगा तो इसे क्या देना?
Because this
अजी एक के trial है न चली. Lutsi court.
the problem is that somebody has to define organized crime, no?
I'll satisfy your conscience. It's my duty to do it. जब वो judgment rely करूँ तो state of Maharashtra से शिवा. नहीं મળે પેલી ત્યાં સુધી હું તો
Yes. Yes.
cleared by Justice Thakur as he then also. Very issue which your honor gets bothered. The prosecutions under the for the organized crime only on the basis of the previous charge sheet, prosecution of so not permissible. So this will answer your query. Now, please turn to para 8. Book page is 1 to 3 5. It was above backdrop of that the High Court held that once the respondent has been acquitted for the offence punishment of section so and so, Arms Act or so and so, and once the trial court had recorded acquittal even for the offences punished under section 4, that is section 25 of the Arms Act, in the Mokoga case number so and so. All that remained incriminating was filing of a charge sheet against the respondent in the past and take the cognizance of the competent court over the period of 10 years prior to the enforcement of the Mokoka. The filing of a charge sheet or taking cognizance of the same did not declare the High Court by itself. They constitute an offence punishable under section 3 of the Mokoka. This is because the involvement of the respondent in previous offences was just and about it one requirement, but by no means only requirement which the prosecution has to satisfy to secure the conviction under the Mokoka. This is what query is and it is answered by the public.
Exactly. And this is a good analogy because once a person is acquitted in those cases, then you cannot say that no charge. But
No, it's not that. I'm sorry, it's a, but the proposition of law is that only because you answer the requirement of continuing unlawful activities would not attract section 3.
it's what happened. What court is saying here is,
Yes.
what I understand is that, okay, in order to book under somebody under Mokoka, yes, you can say that these sections were there, but In those cases, if he is acquitted, or if acquittal has been recorded, then those cases cannot be used against him. As a charge sheet was filed, the prosecution cannot say that the charge sheet was filed then.
The court has gone
But
further.
if
Court
it
has gone further. What was equally, if not more important, was the continuous commission of the offence by the respondent that would constitute the continuing unlawful activity. So long as the requirement is failed, was the position in the present case, there was no question of convicting the respondent under section 3 of the MOCOCA. The reasoning does not, in our opinion, suffer from any infirmity. The very fact that more than one charge sheet has been filed against the respondent alleging the offence is punishable with more than 3 years imprisonment is not enough. The rightly point out by the High Court, the commission of the offence prior to the enactment of MOCOCA does not by itself constitute offence into the MOCOCA.
Not saying that, we are not doing that. So, yes, it has to be continuous. One offence by itself would not invoke. We say continuous, and that continuity should be there, what I understand. If it's the continuity breaks by acquittal or anything else, then it cannot be considered that only the charge sheet was filed. That charge sheet would not.
You are going to take this the act in your hand. First, I'll go through it. Section 3. Mukogadi. Musik. Yeah. I given both the.
Organized crime.
Whoever commits offence of terrorist act or organized crime. The person must be said to have committed either the terrorist act
Or all.
or organized crime. Now, what is organized crime? E means any continuing unlawful activity and terrorist act. Continuing unlawful activities and terrorist act, including, this is inclusive.
No. Whoever commits an offence of terrorist act or organized. That is the reason
Organized
I'm saying- That is the reason I am saying, see, if you come to organized crime,
Hmm.
there you have to, and you would mean something.
Well, I'm coming to that. This is inclusive. Organized crime means continuing unlawful activities and terrorist act. The alone is not enough. Otherwise, it will hit by Article 20. Article 20 says that you can be charged for the act which is offence at the time when it was so committed.
Hey, interrupt here for a moment. There is an amendment to this, in 2023, wherein this word has been omitted. My amendment might or might not be very. But there is an amendment in this GPT of in 2022. Wherein these but two words which the honorable court.
I am not charged in 2022. I am charged as unamended act.
We'll see to
Why
that.
should I bother? Why should I bother the court which is the act which is not applicable?
Definition, it is not charge.
We'll see that. Okay. That is the reason I know that there is an amendment, but I didn't tell him because he was.
But the amendment
I
applies
told
this
him, in the old act also, see, why did the amendment come?
Hmm.
The amendment came in because of this all. And therefore, that other fellow. That is the reason why there was no other reason for amending it.
That amendment 2022. It's not retrospective or retroactive.
No, it is not applicable to you. I'm not even saying that.
Yes.
I am saying, why did the amendment?
Yeah.
Because there was in punishment. It was.
Yes.
Yeah, to or that's why they had to put it out there. That is the reason why the amendment. came. So I feel that way.
But then also, it doesn't make any difference.
Yes. Now see,
One has to answer. Commits an offence of terrorist act or organized crime. Now, pause for a moment here. When commits an offence of terrorist act or organized act, when? The issue is when? From 0001 second of 1st December 2019, not prior thereto. I'll just for academic purpose. Issue has occurred. I'm going to quote the High Court. My clients have been charged for 402, 420, 469, 467. First FIR was taken under the BNS Act.
But in this.
Sir, oh, interesting, the ordinance outside.
एक है खाली. Okay, when you said when, it is defined in later on. That 10 years prior to it, that has been come up later. That's the reason I. When that answer of when is there in the act itself. That is why. But if there is an acquittal, definitely this is acquittal.
No, not required even not acquitted even. I'll suggest it. But I'm just taking a little while out of this context. A matter has been recorded in Sarkara police station 3 days prior. First FIR was recorded under BNS, sent to the magistrate sent it back. This is act prior to 1st July 2024. That act does not apply. Then, second FIR. Under section 406, 420, 467, 468, 471 of IPC. Now, I've spoken because PI knows that you are committing a blunder. See section 358 of the.
The registering of the FIR.
No, it's a
Even if
repeal
they-
act, repeal.
Repeal, no?
Repeal says that what has been done so far is protected. Very issue in case of Mr. Dala. Tata was applied after what I was arguing. That once repealed and no actions taken, that goes. I said that you are committing a blunder. You could have recorded the first information report prior to July 1. Offense committed, suppose offense is committed at 12, sharp 12, murder. And before the 12, you have not recorded FIR. What will happen? You go admit it. The blunder committed by the government by providing the substance. What could have been done? That if offense is committed, then as if it is not repealed. That words are not there.
Saving clause is there.
Saving clause, no, those words are not there. What is suffered is protected. What is not suffered and occurred is not protected. Occurrence is not protected. Sufferance is only protected. And therefore, large number of the offences would go on trial. Large number of. Now they cannot bring back with the retrospective. This is a blunder of legislation.
Verification will come from some high court. Some high court will give a clarification. No,
It has 3 high courts is already held. Punjab and Haryana, Delhi, and I think Jharkhand. Sure, it will come up immediately. But according to my opinion, I mean, I'm not an author, but sufferance clause of the act is defective. And therefore, those actions would go. Now here let us see. The continuation of unlawful activity is not an offense. Please record my submissions. Therefore, answering the requirement of continuity of the unlawful activity. This is the only question I am raising before the court. Continuing unlawful activity, the word is used. Is not answering the requirement of section 3.
Government friends,
You think, कोई
the
organizer
when is defined,
organizer said
defined करें. It has been
Organized crime depend on મારી સામે નથી.
What does it mean?
I'm coming to it. I'm coming to it. The continuing unlawful activity is not answering the requirement of section 3. Then what is required? That is what your Honor further. Require it that any act which is committed on and after 01 second of December 1, 2019, which define act of organized crime or terrorist act. That act should have occurred only after onset of the December 1, 2019 and not prior thereto.
Then even continuing activity has been defined.
Continuing activity has nothing to, it's not an offense. It is a definition.
What is
I'm
offense?
sorry.
Offense is organized crime. Organized crime is an offense.
Yes,
What does organized crime mean? Continuing activity.
no,
That is what it says.
let us see,
Organized
let
crime
us see.
Organized crime means any continuing unlawful activity.
This is not only thing. And terrorist act.
That's why I'm saying when you go to 3 and when you go to E,
Hmm.
there you find the word or. Why do you find the word or in 3?
Because both are offense.
That is the reason why later on came the amendment. But in order to decide this and part, when you say that it has to be read together,
I'll tell you. Let us test it. Organized crime means any unlawful activities or terrorism. That is what want to or terrorism. Section would go immediately. Turn to section with Article 20.
Article 20 has to be read that anything done prior or
No, not prior. I'm sorry. Kalu Kati and the Privy Council. Begum, I will forget both the name. Yes. The act should have been. What is the crime? It is actus reus. Crime is an actus reus. And that actus reus is the act which is defined as a crime at the time when it is so committed.
no person shall be convicted on any offense except for violation of the law in force at the time of commission of the act charged as an offense or to be subjected to any penalty greater than which might have been inflicted under the law for the time.
So therefore, at the relevant point of time, when act is committed, it should be an offense. Therefore, the Bombay High Court has taken the view in another judgment that this 10 years requirement, all this bogus. Decision guidelines.
There will be in the book also. What is the requirement?
Yes.
Is previous offense is the requirement?
Previous offense is a requirement to fall within the category of higher punishment.
That is what.
That's all.
But
But it itself is not constituting a crime. Sorry. I'm not clear to the honorable court. That qualification is for the purpose of guidelines to the judges to punish them severely. It is not an offense.
yeah, it is said that what was equally, if not more important, was the commission of an offense by the respondents would constitute continuing unlawful activity. As long as the requirement failed, as was the position in the instant case, there was no question of convicting here. Why it failed? Because there was an acquittal recorded.
I'm coming to reading.
Whereas
That is what, that is the facts of the case. The law we have to say the ratio decisions. Ratio decision says that continuing unlawful activity would not be punishable. તો સાહેબ ગુસ્સી કોર્ટમાં આપણે તમે નવરા નહીં પડે 50,000 કેસો થશે. And we have to write off Article 20.
Natural expert. Yes, correct. Yes.
ના ના એમાં કેવું થાય?
Yes.
Your lawyer can keep it for the time being.
I'll get a printer for it. Please, correct. We'll get some other.
મેં હવે આમાં છે જ આપું છે. નહીં મળે તો બીજું પ્રિન્ટ કરી નાખું.
શોધે છે.
નહીં મળે તો સાહેબ મેં ઓલરેડી પ્રિન્ટ કરવા કહી દીધું છે. મારી પાસે આની સોફ્ટ કોપી છે.
Let's give us a soft copy.
સોફ્ટ કોપી તો અત્યારે આપી દીધું. Yeah, my colleague is very competent. Para 8 we are ready.
Yes. Come down to inverted comma word.
What was equally, if not more important? 1, 2, 3, 4, 5, 6, 7,
Was the commission of an
10,
offence?
11, 12, and 13th line.
I'm reading that. Was the
Let us
commission
read from beginning again for benefit. It was it was in the about backdrop that the High Court held that once the respondent has been acquitted for the offences punishable under IPC and Arms Act in the crime number so and so, and once the trial court has recorded acquittal even for the offences punishable under section 4, read with section 25 of the Arms Act, in the Mokoka crime number 1 and so, all that remained incriminating was filing of a charge sheet against the respondent in part and taking cognizance of the competent court over a period of 10 years prior to the enforcement of the Mokoka. Filing of a charge sheet or taking a cognizance of the same did not declare the High Court by itself constitute the offence punishable in section 3 of the Mokoka. But this is the law.
independently it cannot be. That is what the law is.
Yes.
Independently, any offense under this independently cannot be. It has to be coupled with some crime.
Yes. That's my argument.
But what I am telling, span of 10 years back. That is where આપણા has been
10 years back માં આપણી સાથેમાં એક પણ ટેરરિસ્ટ એક્ટ કે ઓર્ગેનાઇઝ ક્રાઇમ નું એક્ટ નથી.
definition તો આપણી when they are saying what is the continuing law unlawful.
Continuing unlawful activity is any offense. The second judgment I am coming to it. There continuing unlawful activity is cheating, property dispute, and Mokoka was involved. And the Supreme Court said that this
Because
there is no
Maharashtra
acquittal.
does not allow, Gujarat allow. That is why.
Gujarat doesn't allow.
Gujarat allows, including extortion, land grabbing, contract killing, economic offenses, cyber crime. Everything Gujarat.
When?
Well,
I'm sorry, there is not
including.
including,
As included these are.
but that is when committed, that committed after the one, December 1.
No, that is not. That is not coming into this because they are defining again unlawful activity as continuing. No, continuing unlawful activity has been defined again. What is it?
Continuing activities is bothering your honor much than what is expected.
Therefore, it is bothering. I understand your point that standstill Mokoka would not constitute an offense because any offense would have some.
What is coming from the mouth of the fool? That is it, just it. Accept it. That I have been charged in 2 offenses. Where I have been charged for the offense punishable more than 2 years. Charge sheet has been filed, cognizance has been taken. So I am answering the definition of continuing unlawful activity. Okay. Merely because 2 charge sheets have been filed against me would permit filing.
There is a prerequisite.
I'm sorry. Let me know. Bisect or dissect what we are told or we are made to understand by your senior. When you have to thread bar interpret the statutes you have to bisect and dissect it. Unless you do that, you will not be able to understand the true intent of the legislation. We are testing it on the point that I have been charged for the two offences where charge sheet has been filed. The charge is for the commission of offence, which is punishable than 3 years. Therefore, I am answering the definition to C. Continuing and merely a true charge sheet of 2009. Trial has not been completed. Would permit the police to record the offence punishable in the district court. Because I'm unlawful activity, continuing it. Now suppose I have committed in 2019 one more offence. One more offence where the charge is trivial of what I cheated. Therefore, I am eligible committed the offence punishable for the 7 years. Two previous FIR and one present FIR would constitute Gusti court? No,
Legally,
not technically or otherwise. Because then what is coming from the court is that we are ignoring Article 20. My committing an offence punishable for 3 years prior to December 1, 2019 was not an offence. That act was not constituting actus reus. Sorry. I'm sorry, bro. When I argue, I forget everything. It is 2:30.
so we'll take it up on next day. We start from this much only. Only judgments are left now. So you are going out from when is your flight?
My flight is 6:30.
In the afternoon you will get it. Complete judgment is nothing else is left now. But if you want to explain something more that you feel like
I have to explain because something the query which if I'm not able to.
you'll have to make me unlearn.
Yeah.
Because I have already learned it. So not explain.
For the class I have given.
Because I have already learned this.
Now, there are two titles. I lost it and I'm not able to get it. How to pick your job. Eminent lawyer of the England written a book for the beginners how to make a judge to understand. But title is how to put your judge, how to pick your judge. So shall we meet afternoon or on some other day?
3 o'clock, 3 o'clock. 3, 3:30, 1 o'clock.
I think so, in the second sitting, I'm not there.
Sum up થઈ જાય.
Yes, that is not, my colleague is already.
If you have to say something on the next day, you will say also. But actually, I collect everything and then I ready.
So we are keeping case selection in abeyance.
But this regular.
But,
We are not can.
no, means we are keeping everything in abeyance. He
I
is not available.
You, because it is your application.
Yes, but he is not available for 3 weeks. That is what I learned.
Today you do that also.
Today he'll do, but
Everything.
thereafter he is not available. But some,
So cancellation is.
From
not-
9,
I have heard in Samiji level for cancellation. I want your answers to that. And you are going to finish off from this.
if any more documents are required, I'll forward it. I'll send you.
Whatever you are citing, you can do. Except Kartarking and I don't need them because I have read many, but since you want to pick it, I'll take that paragraph on which you have reflected. What actually taken part by the court. That he reflected in our.
देखो अपील में ये मास માટે સ્ટે કરવાનું રિપોર્ટ અપીલ આજે ટેકોલી ડિસ્કસ કરીને ઇલેક્શન પ્રોસીડિંગ ઓપોર્ચ્યુનિટી
MP, you are not even the government.
ખાલી કરાવી નાખે છે અત્યારે વરસાદ
ને સરકારી વકીલે મેં 2 માર્ક માંગ્યા, સરકારી વકીલને 1 માર્કમાં વાંધો નથી. સાહેબ ખરી નકલ
Matters after a court order.
લો કે છે
One day. Nobody will come to you till the time.
અરે સાહેબ
સર કાલે 30 મિનિટે જતા રહેશે.
સાહેબ રાહ જોઈને જ બેઠા હોય
3 મિનિટે જતા રહેશે.
અને આટલા વર્ષોથી સાહેબ મારો પછી એટલા
15 દિવસમાં જતા રહે.
સાહેબ મહિનો દીધો હોય સરકારી વકીલે ના પાડી.
અત્યારમાં સાહેબ રિપોર્ટ દેવા આવી હતી, પણ ડેટ એટલે જ મારે એક્શન રિપોર્ટ દેવાનો છે આરોપી
નોંધ લેવું કરે છે.
હાલમાં બી સાહેબ પણ એક્શન પુરાણી તો સાહેબ રિપોર્ટ ગ્રાન્ટ સાહેબ નીચે બીકે ભટ્ટ સાહેબમાં આરોપીને
આમ નામ ચાલે છે. કોઈ શહેરમાં ચાલે તો કે વર્તમાન આમ ના આપણા જુનિયર હોય ને તો મેન્શન કરવા જાય ને હાઈકોર્ટ માં કાઢી નાખે છે.
Before end of the day, request is accepted.
University,
ભગવાન that's why I'm here for clarification.
then you are God.
No. So you are
Orders now have been taken. Accepted the orders.
okay. So I just have a small request. If possible, if we make him another. If possible, because I've seen
You know that I'm going to pass order in your favor.
no, I don't
You
know.
don't know
I'm
that
just
you can.
okay. If it's possible then.
Let me see first what to do, what not to do. I'll see the picture.
So they are legal saying I'm doing this thing in all the courts.
I have other matters.
So just 2 minutes.
I have other matters. No 2 minutes now. I've already passed. You say that courts are not going ahead. They are taking 6 months now. When I'm passing an order on the stage level, you are allegation with this. Yes, sir.
So કાલે સાંજે ઓર્ડર માટે હશે
Anytime. You'll be there in tomorrow.
લેટ આવ્યા તો ના મળી જાય પછી નેક્સ્ટ ટાઈમ
None will look at it.
આપણે બોલા વખતે હાજર નહોતા અત્યારે બેઠા છે
Yes, sir. Yes.
Last 7 lines. Please. 1, 2, 3, 4.
1, 2.
Please 1, 2, 3, 4. That reasoning does not, in our opinion, suffer from an infirmity. Violations should often alleged to have been committed by the respondent in the past is but one of the requirements of for invocation of section 3 of the MOPOCA. Continuation of the unlawful activities is a second and equally important requirement that it ought to be satisfied. It is only if the organized crime is committed by the accused after the promulgations of the MOPOCA that he may, seen in the light of the aforesaid charge sheet and continuing taken in the competent court, be said to have been committed offense particular section from there. So what was answered?
You are wanting to say that this prohibition offense was not an organized crime offense. That is what you want to say. And on that day, though Butchika was there, but it was not forming an organized offense. That is
Yes.
what you want to say.
Yes. Now, another judgment. It's possibly page 864.
One second, huh?
हमारी बुक मिलेगी ना मिलेगी
You can understand. हमारा जो कोर्ट शिफ्टिंग में थे everything is gone heavy.
So this is the full bench judgment of the Bombay High Court.
Okay.
Madam,
This Shiva I have written. Now second one, can you say?
second is the state of Maharashtra versus Jagan Gaganchi, Nepali.
Jagal Nepali. ये पेज नंबर
State of Maharashtra versus State of Nepal. Page number 3864. 3864. Which State of Maharashtra versus check to the interpretation of statute. Every provision word must be looked to at generally and in context in which it is used. Elementary principle of interpretation of
any word.
any word while considering the statute is to gather intention of a legislation. Maharashtra control the rule is a system generous, only permissible influence in absence of an indication to the contrary from other advantage cannot be read as suggestion generous with about pecuniary benefits and undue economics. C. Organized crime. Case of the continued unlawful activity. Ingredients necessary to make our case of continued unlawful activities explained. This or this, no, this judgment I would like to read certain paragraphs. Para 4, 5, 6 and 7 are the submissions.
Yeah.
4,
That's good. You want to read?
I just referring
Okay.
to show that. Now, para 10, the definitions has been given, it is reproduced by the court. Now, please turn to para 11. From the procedural of section 2(1)(e),
There, in the peripheral question 2
it can be seen that the following ingredients will be necessary to make the case for the organized crime. That there has to be a continued unlawful activities, that such activities will have to be by individual, singly or jointly, that such an activity is either by the member of the organized crime syndicate or on behalf of such syndicate, and that there has to be use of violence or threat or violence or intimidation or coercion or other unlawful means, that such an activity has to be with objective of gaining pecuniary benefits or gaining undue economic and other advantages of the person who undertakes such an activity or any other person or promoting insurgency. The ingredients of continued unlawful activity would be such that activity should be prohibited by law for the time being in force, that such activity is cognizable, offense punished with imprisonment for the period of 3 years or more, that such activity is undertaken either singly or jointly as a member of the organized crime syndicate or on behalf of the such syndicate, that in respect of such an activity, more than one charge sheet must have been filed before the competent court, and that the charge sheet must have been filed within preceding period of 10 years, and that the court have taken cognizance of such activities. So these are the very important ingredients have been given. In present case, we are only required to interpret what section 2(a) with objective of the gaining pecuniary interest and undue economic or other advantage. Therefore, it is not necessary for us to deal with the other aspect of the matter. For that, it will be relevant to refer to the directory meaning of the word economic, pecuniary, and other. As the flow of lexicon, economic means pertaining to wealth, pecuniary, monetary, relating to money, consisting of money, belonging to or having related to money, and other means different from the which has been specified. We will first deal with the contention as to whether the term other advantages required to be construed as business generis with terms pecuniary benefits or economic advantage. The constitutional bench of the apex court in case of so and so was considering the word otherwise. Apex court observed that the word otherwise in context is contended must be construed by applying the rule of iusdem generis. The rule is that when the general words follow the particular or specific words of the same nature, the general word must be confined to the things of a same kind of those specified. But it is clearly laid down by the decided cases that specific word must from distinct genus or category. It is not an inviolable rule of law, but is only permissible inference in the absence of any indication to the contrary. It can be seen. It can thus be seen that apex court has clearly held that the rule of iusdem generis is not inviolable rule of law, but it is only permissible inference in absence of any indication to the contrary. And the results of journal to purchase, I'll skip it for the time being. Please turn to para 22. Rather, let us go to the relevant discussions. On para 37, page 887. The answer to question lies in the observations of apex court in case of Sanjay Dutt that merely because the statute is likely to be abused cannot be ground for the upsetting its constitutionality or the construction. In this aspect, it will be necessary to report to the judgment of apex court in so and so. Interpretation clauses contained in section 2D, E, and F are interrelated. And organized crime syndicate refers to the organized crime, which in turn refers to the continued unlawful activity. As it present advice, it may not be necessary for us to consider as to whether the word or other lawful means contained in section 2A should be read as the generis or nocital sources. With the words violence, threat of violence, intimidations, or coercion. We may, however, notice that word violence has been used only in section 146 and 152 of Indian Penal Code. The word intimidations alone has not been used therein, but only under section 506 occurring in chapter 22. Thereof refers to the criminal intimidation. The word coercion finds place only in the contract act. If the words unlawful means is to be widely construed as including any or other unlawful means, having regard to the provision contained in section 400, 401, and 413 of the Indian Penal Code, relating of the commissions of the offences of cheating or criminal breach of trust, the provisions of the state act can be applied, which prima facie does not appear to have been intended in the Parliament. The statement and object and reasons clearly state as to why the state act has been enacted. Thus, it will be safe to presume that the expression any unlawful means must refer to any such act which has a direct nexus with the commission of a crime which the Mokeka seeks to prevent or control. Very important. In other words, the offense falling within the definition of organized crime and committed by organized crime syndicate is offense contemplated by the statement of object and reasons. Therefore, these are the offenses offenses under the Indian Penal Code and other penal statutes, providing for the punishment of the 3 years or more. In relation to such offenses, more than one charge sheet has been filed. We have indicated herein before, only because a person cheer or commits a criminal breach of trust more than once, same by itself may not be sufficient to protect the provision of MOCOCA. The apex court held that it will be safe to presume that the expression unlawful means must refer to any such act which has a direct nexus with the commission of the crime which MOCOCA seeks to prevent or control. It is difficult to accept the contention that if the wider meaning is given to the provision of section 2(1)(e), provision of the MOCOCA, which invoke for every petty offences. In case of so and so, some of the offences resulted from quite public water tap. I said better as many of other cases, the accused assaulted injured with the fist blow. By no stretch of imagination, activity could be considered to be the one of the which MOCOCA could be invoked. If there are some altercations between two businessmen within four corners of a shop, and a result for which one of them slapped the other, by no stretch of imagination, it can be said to be an offence for which MOCOCA is also to be applied. Similarly, dispute between the two brothers on some property issues and assault and that too by a deadly weapon would not come within the purview of the MOCOCA. The instance intent is clear that MOCOCA is for the curtailment of the organized crime, unless there is a prima facie material, firstly to establish that there is an organized crime syndicate, and secondly that the organized crime has been committed by a member of unlawful organized crime syndicate and by a person on behalf of the such syndicate. The provision of MOCOCA can be invoked. In earlier paragraphs, we have discussed the details of which the ingredients so as to consider the offence of organized crime the prosecution will. Therefore, have to firstly establish that there is an organized crime syndicate. It will have to be satisfied that there exist ingredients of continuing unlawful activity. It will therefore, thereafter will have to satisfy that ingredients of the organized crime is spelled out by the hereinafter exist prior to the invocation of MOCOCA. Prior to the existence of MOCOCA. We are therefore unable to accept the contention of that if the wider meaning is given, MOCOCA can be invoked even for a sundry offences, as will be the so in the case of so. So this is how it turns out. Once again, post of repetition before I take another judgment. You may not be able to address it.
I want to mainly refer to these only, no? Or you want, you will be referring to others?
Therefore, I'll forward short version. When I come next, I'll give a notice. Which judgment, which paragraph to report, so that you may not have to bulk up the.
On what issue? On what issue?
Yes. Please turn to again. This section 3. Whoever commits an offense of terrorism or organized crime. Please formulate my submission so that you will be able to answer it. My contention is that a person can be charged for the commission of offense under section 3. If a person commits an act of terrorist or organized crime on onset of, very good, on onset of the first day of December 2019. Only because answering the requirement of ingredients of continued unlawful activities as defined. Clause C of subsection 1 of section 2.
Raj cannot be framed on the basis of
Answering the requirement of continuing unlawful activities as defined in section clause C of subsection 1 of section 2 of the Act. Would not constitute 216. Would not constitute the offense defined. Of organized crime. Two one E and Terrorist Act 21H. Now, for our purpose, 2 is worrying the honorable court. More particularly, organized crime means any continuing unlawful activities and terrorist act. And terrorist act. Then the word terrorist act is an inclusive definition. Including. Now, as per the criminal jurisprudence, we have to give a best possible meanings to the language of the statute. It can't be expansive. Please mark it. In criminal jurisprudence, expansive interpretation is not permissible. In civil, yes. The statutes governing the tax and the crime are required to be construed very strictly. Otherwise, it would amount to act of legislation.
should be construed.
Act of legislation
Principle governing crime and tax should be construed.
should be taken strictly. Now, let us come to 21E, crime, organized crime. The organized crime means only one sentence. Any continuing unlawful activity and terrorist act. Now, let us bisect it first, then I'll dissect it. Organized crime means any continued unlawful activity. Then bisect it, and bisect it. Terrorist act. Now dissect it. Number 2. Terrorist act means. Yes. Now dissect it. Take and as or. This document. Now, if you take and as or, that would mean that any unlawful activities, continuing unlawful activities prior to December 1, 2019 would be an act punishable under section 3. Am I clear with that?
Continuing unlawful activity.
Yeah. Continuing unlawful activity alone would invite section 3 punishment. Please turn to section 3 again. Whoever commits an offense of terrorist act or organized crime. So we are concerned with organized crime. Now, if organized crime definitions you take that unlawful, continuing unlawful activity is not required with the support of terrorist act. You read two provisions.
Because
Offense of terrorist act or organized crime. Organized crime itself shows terrorist act.
organized crime consists, what is an organized crime? There you have to take two definitions. Continuing unlawful activity and terrorist act. Both have two different meanings according to the act,
Yeah,
because they are defined.
yes.
So whether the defined definitions given in continuing unlawful activity is different from the terrorist act.
Now, sir, please refer the section 2E again and 2H. Organized crime means continuing unlawful activity and terrorist act, including extortion.
Included.
Okay. Then land grabbing, contract killing,
Everything.
economic offense. Okay. Now terrorist act, H. Terrorist act means act committed with intention to disturb public order.
Only that much. Matlab, that terrorist and this terrorist is different. They could have used some other word also, but now they use the word terrorist. It's not, I cannot say that they should have used that word, but that terrorist and this terrorist is something different.
Police drafting. Because it is drafted, whether it says, what is not.
I cannot.
Not
say
for your
anything.
convenience.
I cannot say anything.
I say it's not for your convenience.
But
Because we know the contract has been given to the firm, owned by the daughter of Justice P.M. And all legislations have been done. And legal, what was it? That's a word, Mr. Mankar. He was pioneer in legislative department. Up to previous boards and every officers were there. They were IS officers or GS officers. They were well trained in drafting. And they knew the meaning of every word, every comma, every semicolon, every colon, where to put or what. If you read the textbooks, how to draft the legislation.
But they have included this also. They have included both terrorists. Or certain unity, integrity and security of the state. Or strike terror in the mind of.
Here the principle of the full bench of the High Court, the Bombay High Court is to be applied. Principle of existence, generous will have to be, or principle constitutional process will apply. Terrorist act means what? This terrorist act alone. And the defined under the argument would be one day come before the court. That mere terrorist act without an intention to disturb the public.
This issue has never been decided by any court in Gujarat.
No.
Till 2019, 5 years.
So it is कोई
5 વર્ષ થઈ ગયા
5 વર્ષ માં એક ટ્રાયલ ચાલી નથી ને
ડિસ્ચાર્જ તો ચાલી હશે ને
એક કે નથી this is first discharge you are deciding you will be a pioneer.
It is ridiculous. In 5 years, if no discharge application is decided,
bail application નથી decide થતી. હમણાં justice Mengde has decided some of the bail applications. Bails are not decided.
but what about what orders we are giving from here? I have given 3-4 applications orders from here. અહીંયા
અમારા
decide
ગયા એ મેંગડે સાહેબે decide કર્યા.
એની પેલા પણ સાહેબ કરી કે આપણે ઓર્ડર્સ ડી લિસ્ટ રજૂ કરીએ છીએ સાહેબ 2022-23 નો ઓર્ડર
એ રીતે ટ્રેન જ રહું.
Allowed નહીં.
મને ખબર જ નથી. હું આ ફિલ્ડમાં તારીખ
allowed with that.
મને ખબર છે. સાહેબ આનો આ કાયદાનો સૌથી વધારે દુરુપયોગ બીજા પર્પઝ માટે થાય છે. Either political or some other
That
concept.
he cannot go into, that is
Yeah.
okay. You can understand. But 5 years have gone, if
Nothing has happened.
nobody has interpreted this.
To my knowledge, not. I never get the point.
From Rajkot, this is only a discharge application. રાજકોટમાં એક જ કેસમાં discharge આપશે. TDC માં કોઈ accused કરે. બીજા કોઈમાં રાજકોટમાં
That is okay. 5 વર્ષમાં તો કંઈક decide થઈ જવું છે. It becomes easier also.
Whatever you say would be the idea and it will be tested by the higher court.
It has to be. Okay, you go ahead. High Court not to issue. Nobody has raised in 226 also.
Pending rates,
But then what was it decided?
pending for the final, so it was heard once by the previous CJ.
No,
CJ.
any, not this matter. Any other matter also.
બધી એ તો group together છે. બધી group together છે. હવે આ present chief justice લેવાના મૂડમાં હતા, but now she is going back to Delhi. She is expected to go back within a few weeks. But now see, I don't.
We
see
are,
any
we are so
information.
far from Ahmedabad, we don't have any news about that. But somebody ought to have decided. It is now high time that interpretation to આવી જાવ. Mokoka, everybody is relying on Mokoka. And Mokoka is something which is a very lighter act than Gutsikta.
Yes,
Because there is no terrorist word.
This is personal Tara.
It is there. Because in that prior offenses was that prerequisite of prior offense was not there. So if you are committing there and then yes. Before coming into the force, it was not an offense. In Ghana. Here it is. This is yes, even prior.
Therefore, in Bharat charge case, the Supreme Court changed it. And previous offenses may the guideline.
But Mokoka I can understand.
Here also it cannot be there.
Here they are making, they have,
So एक बार
and it is a,
I'll tell you one thing. I'll like to stop you. Once you hold that the continuing unlawful activities is also an offense under section 3. Because and is required to be read as law. Criminal laws, you are not permitted to do that.
and then if you remove the and, no, it becomes more problematic because the definition is given of two things.
I'll tell you. Three, the offenses, silly offenses, I'll tell you. 3
No,
years.
no, no, I'm not talking about this case. I'm talking about.
Yeah, I'm
the
talking
amendment.
general, silly offenses. Suppose somebody is facing 50 criminal cases of all bootleggers would be charged under the Rajkot. All bootleggers.
One more offense of bootlegger after the coming into the force and.
Would invite Rajkot.
હમણાં પાછા કરે છે. હમણાં તો પાછા
એ તો પાછા નહીં
more
થાય.
prevalent.
પાછા નહીં થાય.
ના હવે તો પાછો પ્રિવિલેજ છે
હા.
ત્યારે ભોગમાં છે
હા.
કે એ જ ચલાવે છે કે 5 કેસ થાય તો પાછા કરી દો પાછો This can also be done.
પછી માનો કે કોઈ ચીટર છે, કોઈ સાયકલ ચોર છે, મોટરસાયકલ નો ચોર છે.
But then you have to bring it, there has to be a syndicate also. Unless and until the syndicate comes into place, you cannot bring anybody into part.
That is what is my first argument. કે આમાં કોઈ syndicate છે જ નહીં. તમે બધી FIR વાંચો ને સાહેબ. I did not bother you. So I want to read all 8 FIR. There is no syndicate. કોઈ જગ્યાએ એવું નથી લખ્યું કે આ ફલાણા ફલાણી ગેંગ ના સભ્ય તરીકે અથવા ગેંગ વતી સ્વતંત્ર રીતે આ દારૂ બોટલ લાવ્યો છે, આ હથિયાર લઈ આવ્યો છે. That's right. Why this matter was referred to this? I have not read the facts. There were 4 cheating cases. Always referred. 4 cheating cases. In those cases, charge sheet was filed. And he was.
See, we cannot even make.
Full bench said that what nonsense is going on? Cheating cases you are involving Mokoka.
Because the word used is economic object.
Yes. Therefore, they said or other. Why this term was required to be interpreted or other? Have you heard the history of Justice N.B. Patel?
Who is this anybody?
For which the High Court was closed for 3.5 months.
It must be very long time.
83.
Before I came to Gujarat. Before I came to Gujarat.
He had given an excellent judgment as a JMFC Shigor. It was so nicely written judgment. Matter has gone up to the Supreme Court. And Supreme Court says this kind of judges are our assets. This is a matter of history. Report. Then he was eventually given a promotions and was appointed as district judge and secretary to the office of Gujarat in the place of Madhus. He did not agree with all the suggestions made by the chief. Like I'm the secretary law and legal affairs. I have an independent view. If you say that to file an appeal, I will not say. There is no merit, I will not suggest to file it. And then he was called by the chief minister and was asked to sit by chamber from 11 to 5. Justice Diwan was the chief justice. He immediately reported. And he said, he will come back. And Chief Justice returned a letter that no judicial officer would be now appointed. The secretary of the court. So, matter went for long. And then he was bypassed for elections. And the High Court was closed and ultimately he was to be. The judgment, well written, well thought judgment, doesn't go unnoticed. This would be one of the judgment. I don't know where deciding what manner, whether in my favor or against me. It's not an issue. Issue is what is the correct interpretations. Now we are on the issue of bisect and dissect. If you remove the word and please read it. Let us read this. Organized crime means. Read along with me, sir. The organized crime means any continuing unlawful activities, terrorist act, including extortion. So, you have to read 2E, that with section 3. Whoever commits an offense of terrorist act or organized crime. Now, organized crime would any unlawful activity, any continuing unlawful activities that would come to organized crime. Then what happens to Article 20? The offense which is committed in 2009 onward. On and from December 1, 2009 till November 30, 2019. Where the charge sheets have been filed for the offense punishable under for the punishment for a period of more than 3 years would be committing an offense of a organized crime, which was not defined as an organized crime when that act was committed. then question arises. The legislature doesn't use the words unnecessary. It's not a redundant. Then what is it? It is for the purpose to have a more stringent punishment. Because they want to control something. It is the guidelines. Judgment and everything I'll go when I think. I think I'm clear on the issue.
Now, a minute. You will give all judgments with issue number this.
If you don't mind. આપણે લઈ લો ને પાછા.
લઈ જાઓ. એના ઉપર જ
એના પર માર્ક કરી, બોલો કરી બધું આપણે. If you don't mind, I'll flap it and mark it.
Para number two.
Mark करूँ कि पैरा नंबर आपको?
Para number, para.
Mark नहीं.
I won't need, I'll read the whole file.
मैं टिकट with I do.
No,
दस बजे
you give it all.
before 8.
8. Before 8, no? So you'll be back on
27.
no, when are you back? Abhi, you're going out just now today.
The movement for one
Monday. You keep it tomorrow? No, day after. Second,
चार दिवस સુધી સુધી રિપોર્ટ ભરાય પડ્યો.
third, fourth, fifth, sixth. 5, sure. You are only now required to give me judgments. Only they will be arguing.
Yes, sir. I told you.
Yes.
7.
7.
That's right. But before purchase.
No.
That is better. It might be like what, like 1 o'clock, something you can come. 1:30.
Okay.
We'll start there. Then we'll start.
Seven.
7 first you will argue your bill. Calculation. Then you will counter this. खाली हम नहीं रख. खाली हम खाली ये भी अर्ली to bill. I'll take it up a little bit. And I will say not.
You can add something more.
That they'll argue in 7. They'll argue the bail yesterday.
Everybody is required to be released on bail. There is no basic offense. Every offense registered against all the accused are prior to December 1, 2019. And none of the offense is a member of bail. There is no their case. When this starts it also, there is no, they cannot say that this offense has been committed with the gang. There are 16 of the charges. અને છેલ્લું જે 3 લાઈન લખે છે એટલે કે આ લોકોએ કન્ટિન્યુઇંગ અનલોફુલ એક્ટિવિટી ચાલુ રાખી છે એટલે that itself is destructible to prosecution. રાખવી તો રાખો.
ના પેલા application કરવાનું.
Okay.
અને this is only on this. મૂકી રાખવાનું તો બધું. Like કાચને let it be. Just have a listen. એક comparative study કર લે.
We will have new edition next year. I'll give this. I'll call for one more session.
And we'll order from the library. We want one. We'll order. I'll keep this one, but we'll order one. Yes.
I take you.
ક્યાંથી આવો પડે હા વાંધો નહીં. આ કઈ ભેગી તારી પાસે ઈ લે નહીં આ બધું ભાઈ આ છે ને આ એક કામ કર્યો બધા અલગ અલગ ફોર્મ આ બીજા પછી